Hello everyone, welcome to Courts Today by Live Law, your go-to source for the latest and fastest legal updates. This is your host Urvashi Chauhan, here to bring you daily developments, landmark judgments and significant rulings from the world of law. Let us begin with the headlines and after that we can delve into the full details. The Supreme Court has reserved judgment on the Madarsa Education Act 2004 matter. The Uttar Pradesh government has told the Supreme Court that it will not act on demolition notices against houses of accused in the Bahraich violence case. The Supreme Court has extended interim anticipatory bail granted to Malayalam actor Siddique in a rape case. The top court has permitted Teesta Setalvad to travel to Amsterdam for International Documentary Film Festival. The Kerala High Court has held that husband pledging wife's gold without her consent is criminal breach of trust. And the Delhi High Court has denied bail to Shahrukh Pathan in the Delhi riots case. In an important update, the Supreme Court today reserved judgment on a batch of petitions filed against the judgment of Allahabad High Court, striking down the Uttar Pradesh Board of Madarsa Education Act 2004 as unconstitutional. Before the High Court, a writ petition was filed challenging the authority of the UP Madarsa Board as well as objecting to the management of Madarsa by the Minority Welfare Department and other connected issues. A bench comprising CJI D.Y. Chandrachud, Justices J.B. Pardiwala and Manoj Mishra, which started hearing the matter yesterday, completed the hearing today. Senior Advocate Mukul Rohtagi argued that according to Article 28, Clause 2 of the Constitution, the rule against giving religious instruction in state-funded institutions does not apply to schools or colleges run by the government but set up through a trust or endowment that requires religious teaching. This means that institutions managed by trusts can legally provide religious instruction. He added that the High Court's judgment was actually against the principles of secularism as it had the effect of depriving minority students of their rights. Next, Senior Advocate Menaka Guruswamy for the petitioners referred to a Constitution Bench judgment stating that the minority religious institutions are excluded from the RTE Act. Further, responding to the arguments of Senior Advocate Guru Krishna Kumar for an intervener opposing the Act, the CJI asked that what was wrong in the legislature recognizing an institute imparting religious instructions and mandating that they should follow certain basic standards. Striking down the entire Act would mean that the Madarsas remain unregulated. CJI pointed out that the Act gives rule-making powers to the state to lay down standards. Senior Advocate Krishna Kumar then argued that the Act does not ensure secular education and was mostly focused on theological studies. The Act does not enable children in Madarsas to be at par with mainstream individuals. Senior Advocate Madhavi Diwan appeared for an intervener opposing the Act. She submitted that Madarsa education negated the promise of quality education guaranteed under Article 21A of the Constitution. While one has the freedom to take religious instruction, it cannot be accepted as a substitute for mainstream education. Diwan further argued that the scheme of the Madarsa Act gave predominance to religious scholars in the board composition, and this would mean that the children would be exposed to only one worldview. When the CJI pointed out that there are other similar religious institutions which children join at a young age, Diwan replied that those are instances of people taking monastic vows to renounce the world and cannot be compared to Madarsas, where the students are not seeking to renounce the world but to live there. She submitted that for pursuing professions like Navy, pilot, engineering, etc., the students of Madarsas will not have the opportunity as they are not studying the related subjects. Moving ahead, Senior Advocate Swarupama Chaturvedi, appearing for the National Commission for Protection of Child Rights, stressed that the Commission has no objection if Madarsa education is a supplement to the school education, but it cannot be a substitute. The bench also heard senior advocates Abhishek Manu Singhvi, P. Chidambaram, Salman Khurshid and M.R. Shamshad in brief rejoinder submissions on behalf of the petitioners. Singhvi said that the striking down of the act amounts to a virtual ban of the Madarsas. If there are deficiencies in the standards, the state should exercise its powers under the act to improve them instead of dismantling the whole structure. He added that all modern subjects are taught in the Madarsas. Chidambaram suggested that the service conditions of the teachers in Madarsas be made the same as other teachers. Also, let me tell you, the state of Uttar Pradesh, which has chosen to not challenge the High Court's judgment, took the stand that it was wrong to strike down the entire act and only the violative provisions needed to be nullified. The judgment has now been reserved. Stay tuned with us to know the verdict. You must have heard of the recent incidents of violence in Uttar Pradesh's Bahraich due to a communal flare-up allegedly after a group of people objected to loud music in front of a religious institution. A 22-year-old boy was shot dead, after which the district was on edge for days, witnessing various incidents of arson and vandalism, forcing the authorities to suspend internet for 4 days. Some shops, houses and vehicles were vandalized. A car showroom was set on fire. Recently, the authorities issued notices to demolish the buildings of certain residents of Bahraich who are named as accused in the FIR relating to rioting by alleging that their constructions were illegal. 3 of them filed an application before the Supreme Court on Sunday for protection against the proposed demolitions. Let me tell you, the Allahabad High Court is also seized of the matter regarding bulldozer actions. On Sunday, after an urgent hearing, the High Court granted 15 more days to the persons to respond to the notices. Today, Senior Advocate Chandroday Singh mentioned the application before the bench of Justices B.R. Gavai and K.V. Vishwanathan of the Supreme Court. Justice Gavai said that the court will take up the application tomorrow and ask the Additional Solicitor General to defer action. In response, the ASG today told the Supreme Court that the authorities will not act on the demolition notices till tomorrow. The same bench, let me tell you, had last month passed an interim order that no construction would be bulldozed without prior permission from the Supreme Court, except those that are encroachments on public spaces. And recently, the same bench has reserved judgment on a batch of petitions seeking directions against bulldozer actions by various state authorities, whereby houses of persons accused of crime are demolished as punitive action. In the next update, the Supreme Court has today extended interim anticipatory bail granted to Malayalam actor Siddique by 2 weeks in a rape case registered against him based on allegations levelled by a young actress. Following the publication of the Justice Hema Committee report regarding exploitation faced by women in Malayalam cinema, the victim in this case had made public allegations that Siddique sexually exploited her in 2016 when she met him in a hotel room after he offered her opportunities in the film industry. Last month, Supreme Court had granted anticipatory bail to him, which was extended today. Senior Advocate Ranjit Kumar, appearing for the state of Kerala, submitted that Siddique was not cooperating with the investigation and was destroying the evidence. When the bench pointed out that the complaint was filed by the victim 8 years after the alleged incident, Ranjit said that the victim mustered the courage to come out with the allegations following publication of the Justice Hema Committee report and requested the court to understand the delay in filing of the FIR in that context. Advocate Vrinda Grover, appearing for the victim, said that she had been repeatedly raising the issue in her Facebook account since 2018 and that it is difficult to go against a superstar in the industry. The bench comprising Justices Bela Trivedi and Satish Chandra Sharma today adjourned the hearing after Senior Advocate V. Giri for Siddique sought time to file a rejoinder to the status report filed by the Kerala Police opposing his petition. He added that after the court's interim order, Siddique has appeared before the investigating officer. And now let me tell you, the top court has today permitted human rights activist Teesta Setalvad to travel to Amsterdam for the upcoming world premiere of her documentary, Cycle Mahesh. Last year, Setalvad was granted regular bail in the Gujarat police case over alleged fabrication of evidence in the 2002 riots cases. One of the conditions imposed for bail was that her passport would continue to be in the custody of the Sessions Court. Today, her counsel, Senior Advocate Kapil Sibal, submitted that her passport needed to be released for 30 days for her to apply for a Schengen visa to travel to the Netherlands from 14th to 24th November. She has received an invitation from the International Documentary Film Festival Amsterdam to attend the festival in her capacity as producer of the documentary film. A bench of Justices B.R. Gavai and K.V. Vishwanathan allowed the release of her passport on the same conditions as stated in the August 2024 order, by which she was granted permission to visit Malaysia to attend an anti-racism conference. Let me tell you, it imposes two conditions. First, an undertaking to be filed by her stating that she will return after the aforesaid period. And second, a solvent security of rupees 10 lakh is also required. Apart from this, the passport would be returned after she comes back. The Kerala High Court has refused to intervene in the conviction of a husband who was found guilty of criminal breach of trust under Section 406 of IPC for pledging his wife's gold without her consent. Criminal breach of trust happens when someone is trusted with property or money and uses it dishonestly. It means breaking the trust by using it for personal gain or in a way not agreed upon. If found guilty, the person can face jail up to 3 years, a fine, or both. The prosecution case here is that the mother of the wife gifted her daughter 50 sovereigns of gold ornaments during her marriage. The wife entrusted this gold to her husband, asking him to keep the same in a bank locker. But he, without his wife's knowledge, pledged the gold to a financial company. The trial court convicted him and sentenced him to undergo simple imprisonment for 6 months. When the case came before the Sessions Court by way of appeal, the court, in addition to the 6 months simple imprisonment, directed the accused to pay compensation of 5 lakhs to his wife. The accused challenged this finding, saying that the offence is not made out from the evidence. Single bench of Justice A. Bahaduruddin has now held that all the elements of the offence are made out. That the husband was entrusted with the gold which he dishonestly misappropriated and converted it to his own use, violating the trust of his wife and causing her loss. Therefore, the order of conviction was upheld. During the Northeast Delhi riots in 2020, among many videos, one which went viral on social media was that of Shahrukh Pathan, who was captured pointing a gun at a policeman. The FIR was registered against him for the offences of rioting, promoting enmity between different groups on grounds of religion, attempt to murder, etc., and under the Arms Act. The trial court in December 2021 framed charges against Pathan and other accused in the FIR. It had also convicted a man for harboring Shahrukh after he had voluntarily pleaded guilty to the charge framed against him. Today, Justice Dinesh Kumar Sharma of the Delhi High Court denied bail to Shahrukh. He had approached the High Court after the trial court denied him bail in December last year. According to the trial court, bail could not be granted considering his bad conduct in jail before his arrest and during court proceedings. The court highlighted strong evidence against him, including eyewitnesses and the video showing him firing at a head constable during the riots. Additionally, the recovery of a mobile phone from him in the jail was seen as poor conduct, further supporting denial of bail. For more details on the cases that I mentioned, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Please do not forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.